Welcome to our webinar, Expanding the Application of TJ, Insolvency and Financial Rehabilitation, and Online Dispute Resolution. My name is Advocate Itai Kryden, a director at the Non-Adversarial and Therapeutic Justice Center at the College of Management Academic Studies, Strix Faculty of Law. Shalom. We are delighted to have you here with us today for this webinar. Your presence is highly appreciated, as I said. Furthermore, I want to thank again to Shelley, Pauline, and all our great colleagues here for this amazing platform, an important platform to share insight from around the world. It is a great webinar series. This webinar will explore exciting topics and how TJ may assist shaping better norms, procedures, and practices. During the first part, we will focus on insolvency and financial rehabilitation. The second part will discuss the importance of TJ around the subject of online dispute resolution. Today's panel of experts will share their insights and experiences from judicial and academic perspective. We hope you find this webinar informative and valuable. And without further ado, let's get started. So I would like to introduce our participants today. We have Judge Dr. Dan Saadon. Personally, I would like to thank you for joining our panel today. In 2016, Judge Saadon was appointed as a judge of the Magistrate Court in Tel Aviv District after serving in several judicial roles in several other tribunals. In 2021, Judge Saadon received the Doctor of Philosophy degree from the Tel Aviv University. I would like also to introduce my colleague, and we've been introduced by Shelley, Dr. Kani Perlman. She's an academic researcher and lecturer in the field of law, conflict resolution, alternative dispute resolution, TJ, of course, and she's the founder of our center of the Non-Adversarial and Therapeutic Justice Center in the Strix Law Faculty in the College of Management. And myself, for more than a decade, I'm practicing as a lawyer, international, commercial, and corporate immigration law, mediation, therapeutic jurisprudence, and together with my colleague Carney, we are adding the center and also trying to be what we called a good TJ ambassadors. Few words about our center. We founded the center back in 2015 at the Law Faculty of the College of Management. We are among the 5 best law schools in Israel. Our main goals, in accordance with the TJ's point of view, is to examine legal rules, different procedures for dispute resolutions, and the role of dispute resolution managers, such as judges, arbitrators, and mediators, and to suggest different changes that will lead to better therapeutic and restorative results. Now, you can see on the screen, I will cover it very briefly. We focus on knowledge. It's one of our main goals to start in the law faculty. We do believe that if you start early with knowledge and education, also for the general public regarding TJ and to other practitioners, high quality and efficient practices. Again, we're speaking about the judges, lawyers, mediators, social workers, and other practitioners. We conduct research in the field of therapeutic jurisprudence and collaborative law. We also conducted several researches in the topics that we will discuss today, ODR and insolvency and financial rehabilitation, and many others. And we do like I think most of you, international activities, because TJ is a community, and as much we will strengthen this community, we will reach different eyes. Now, again, in a very brief way, I want to present some of our activities, conferences and seminars. We just recently participate in a very large conference of one of the leading, biggest mediators organizations in Israel. It was like different tables, and it was very important for Kani and myself to make sure that there will be a table dedicated to TJ. We also participate, for example, in one of the well-known conferences in Israel and initiated a panel discussion related to therapeutic jurisprudence and mediation and people with disabilities. Think about the important role of such tables, such a panel discussions among such a conference. Now, we also initiated some other conferences related to TJ in Israel with also legislators, because it was one of our goal to expose our legislators to TJ and to see how it can be involved. As you know, we are serving as the Israeli chapter of the TJ community. We have also lectures and we do international cooperation. We saw Michael Perlin, our great colleague, that participate. Thank you, Michael, for joining us today. And we are publishing articles, whether it's academic and non-academic journals, and position papers, can you write position papers in very important topics like sexual crimes and many others that we are involved. We are taking part in podcasting and e-learning. It's also another very important channel that we see to reach the public and to share knowledge. Actually, our first and second chapter of our podcast is dedicated to TJ and the community courts in Israel, which again brought more to the public and to people who are interested about TJ and activities related to TJ. And we are encouraging students to conduct research about TJ and topics related to TJ. So we have our internet site and our Facebook site. There are much to talk about and much cooperations that we can do. And again, without further ado, I would like to reach our first topic for today: insolvency and financial rehabilitation. And for the sake of general background, I would like to cover first the Israeli Insolvency and Financial Rehabilitation Law entered into force on September 2018, regulating insolvency and financial rehabilitation proceedings in Israel. An insolvent person is a person who is unable to pay his debts on the date they are due, or a person whose liabilities are higher in value than the value of his assets. So we will cover the law, which is, we call it the new law. It's relatively quite new from 2018. We will focus today on financial rehabilitation as an important institution within the law and in the judicial practice. It is important to note that we will focus on individuals, on rehabilitation of individuals. It's our quite interesting times with the collapse of Silicon Valley Bank and the moral basis, or when the government, legislators, and different practitioners should back up and help, and in which way for organizations. But we will focus today on individuals. We're going to have a very important and guest as today. It's Judge Saadon, and which will bring his perspective both from academic and judicial point of view. And of course, TJ is going to be the frame of the discussion today. So before moving to the conversation with Judge Saadon, we just decided to bring you some of the explanatory notes to the bill in preparation for the enactment of the Insolvency and Financial Rehabilitation Law. So the first goal, and I'm emphasizing the first goal of the law, is the financial rehabilitation of the debtor. The financial rehabilitation of the debtor serves the interest of the creditor, but also intend to achieve broader purposes. The economic rehabilitation of debtor benefits the general economy, and it also promotes other social values. The financial rehabilitation of the individual has many economic advantages, and alongside them, the fulfillment of social principles of providing another opportunity. Financial rehabilitation allows the debtor to restart financially and contributes in various circles to the debtor himself, his relatives, his personal and economic environment, and society as a whole. So I think when we take in the background this quote, I would like to start and thank again Judge Dr. Dan Saadon of the Magistrate Court in Tel Aviv District for joining us today. And for the sake of the conversation, I will stop now the sharing and we will be able to discuss. Judge Saadon.
Hello.
Thank you very much for joining us today. It's our honor to have you today in our discussion. I think that we will start with a short but very important question that a lot can be told about. And in your opinion, what is the proper meaning of rehabilitation?
Well, the term rehabilitation has different meanings in different areas of science and social sciences. According to my research, I did my PhD on debtor rehabilitation. According to my findings, a rehabilitation process is a process which can unlock the full potential or the fullest potential of the debtor. It means removing any limitations from the person involved to reach his utmost potential regarding his abilities, regarding his education, regarding his position in life. Of course, it's not in absolute terms, but relatively speaking, it can help him reach a better standing in life, unlocking his full potential. This, I think, is the most general and the general definition, at least my definition, for a rehabilitation. In economic terms or in financial terms, it means that when a person comes to you as a judge to your court with a financial problem, you have to diagnose what are the things that enable him or disable him from reaching his fullest potential. And accordingly, you have to build a scheme in order to help him, to intervene, and to help him reach his full potential. The main problem with this point of view is that courts don't usually have the means, the legal means to intervene in the way that I, as a scholar, would like to intervene in order to unlock the debtor's fullest potential.
So it's very interesting because the term, as you say, rehabilitation is not necessarily clear and it can be taken in different directions.
Yes, the interesting thing about the new law in Israel is that the legislator put the term rehabilitation as the utmost important thing in according to him, but it did not give a specific explanation about what exactly is this rehabilitation, what does it meant to achieve, what the court meant to achieve. As a matter of fact, courts around Israel right now, each judge is acting on his best knowledge or his best intuitions about what is or what ought to be a good rehabilitation outcome concerning the debtor. And according to this specific notions or these personal notions, he conducts the insolvency process. I don't think it's an optimal outcome, but given the circumstances, it's better than what was before.
Right. So I would like to ask you whether with connection to the definition of rehabilitation and or other aspects and from comparative global perspectives, can you provide examples of the legal framework regarding insolvency and financial rehabilitation in other legal jurisdictions?
Yes, I think it's an interesting question regarding the Israeli law, because Israeli law, the current Israeli law, borrows a lot of features from other Western countries' legal schemes about insolvency. For example, it borrows from the USA and from Canada and from England the concept of automatic discharge for debtors. From Western Europe, European countries, it borrows the notion that the main asset in which the debtor pays his debts as is, in fact, his ability to work and pay from his earnings his debts. And according to that, we as a court, I as a court, we build a scheme of payments for several years, from 3 to 5 or 6 years, in which the debtor pays monthly. And in the end of this this payments plan, he receives an automatic discharge, pretty much like in Europe nowadays, and like in the United States under Chapter 13, which is a chapter in the bankruptcy code of the United States.
Just
we also borrowed the notion of can pay, should pay from the USA. Today, one of the most important things that we try to achieve is to differentiate between people who can pay, and for those we provide a payment plan, and those who can't pay will receive an immediate discharge.
Judge Saadon, just for the sake of clarity, when we speak about discharge, is the ability of one to get the discharge from his debts and actually back into the normal business life without.
This question relates to my definition of rehabilitation. According to my perspective, if you have problems, I mean, not just financial problems, but other problems like drug or alcohol addiction, or other problems like handicapsy or anything else like this, a mere discharge will solve your debt problem, but it will not re-engage you to society as a member with full capacity, because we didn't deal with your core issues that prevented you in the first place to be in financial troubles. This, I think, is the main thing that our law in Israel and other laws in the Western world today fail to address. And I think that if we would have addressed these fundamental questions, maybe we will really promote financial rehabilitation for debtors. But right now, we focus on the economic problem, which is not merely the whole problem of debtors. And doing so, I think that we miss a great deal of the complexity of the problem and address merely a relatively simple aspect of this problem.
It do leads us to another question regarding rehabilitation. What are, again, in your opinion, a successful rehabilitation process? Now, we can speak about, of course, the tools that you have today as a judge in the court, as well as the vision, which tools can bring to successful rehabilitation.
I think that a successful rehabilitation means that a person, a debtor, who suffers from core issues that prevents him to function in his optimal ability in society, in modern society, will get rid of these disabilities during the process or short time afterwards. Nowadays, most people who are adjusted and succeed in rehabilitation are basically people who suffered a misfortune in their economic business, and they failed financially. But in other terms, they are very well equipped to handle the economic life. So if we delete their debts and we send them back to society, they will succeed, and the rehabilitation will be full. Conversely, people who suffer from other issues, who manifest themselves in debts, if we will delete their debts in discharge, I don't think we'll get full rehabilitation, because the core problems will remain, And the courts in Israel, and I think other way in the Western world, are not equipped to deal with such complexities and to deal with the core issues that the debtor suffers from and cause their financial crisis.
Among your answers, how long takes today in the new law this journey from entering the process of the insolvency until you get a discharge?
How long?
Yeah.
Well, basically, you have a first year in which the process is, there's a decree that the process begins. And in the first year, they check on you financially. They check about how are you, like from your educational point of view, your occupational point of view, your familiar, your domestic point of view. And then they try to assess a scheme that will optimistically rehabilitate you. And this will take between 3 years, which is the baseline, 3 years until for 5 years or 6 years the most. And during these years, you have to pay a monthly payment plan, in which in the end, if you succeed with all these stages, you receive an automatic discharge.
It's very interesting. We will touch later on in connecting more to TJ that the process of rehabilitation naturally is a process that takes time. And when we speak about rehabilitation, it's not always something that's reaching easily, meaning that there can be different corners along the way. With your permission, maybe I can ask whether my colleagues here in the conversation would like to ask something. It will be okay?
Of course.
Thank you. So I would like to allow you to ask questions, please.
I guess, I mean, I thought this was absolutely wonderful. And what I was so struck by was your perception that just simply discharging the debt may not be enough. If there is a person with an addiction or habituation, or a person with a disability who can't find employment. And one of the things that has always vexed me, I practiced law for 13 years before I became a professor, was how we cabin different areas of the law completely separate from each other. So, I mean, I know nothing about bankruptcy law. I mean, garnished, is absolutely zero. But I'm thinking to myself as you're talking, Judge, wow, all the connections that could be made. I have no idea, Itai, whether there's so much literature in disability rights law. I have no idea. And I'm thinking the answer is either none or almost, these few articles have been written about the relationship between disability law and debtor law, putting aside the TJ piece, which I'm going to wait for a while to raise. But I just thought this was so wonderful. And I'm just so happy to hear it, especially I was going to say, Judge, I wish I had practiced before you, but I'm clearly much older than you are, so that never could have happened, But wow, to have a judge with this kind of sensitivity and sensibility to the issues, I've said that to Pauline all the time, it's spectacular, that you see this and you get it. And this was wonderful. That's all.
Thank you. Thank you.
I just want to add to that. Hello, Pauline Spencer here. Sorry about being a little late. It's fascinating that the group of people you refer to, Judge, who might have other issues that are driving the debt, and that if the financial rehabilitation happens, that's only part of the issue. And just the term rehabilitation. So I work in criminal law and offender rehabilitation. And we know, say someone is, stealing something from a shop regularly, and they might have other issues that are driving that, such as addiction or gambling or poor mental health or a combination of all of the above. And so, in the criminal law, a therapeutic justice approach has been to have a program attached to the court that then assesses those needs and then case manages by linking that person in with those other services. And then the judicial officer actually playing a role to motivate that engagement in that process and encourage people to, you know, get engaged in those services. And then that's something that's taken into account in the final outcome. So, you know, that's interesting that is, as Michael's saying, that's happening in that area, but you could see that very much applying in your area as well as an approach.
Yes, I see many relative topics overlapping between criminal law and insolvency law regarding rehabilitation. But unfortunately, in rehabilitation, the problem is defined as an economic problem, not as a personal problem, not regarding the core issues of the person involved, but rather his economic debts and the need to solve solve, like in inverted commas, solve this problem by deleting the debts and not by dealing with more complex and more profound issues that concerning this individual's function in society or in economic society. In criminal law, on the other hand, there's a much broader perspective to the court. In Israel, it's community courts, to deal with the right tools, the right intervention tools in order to heal or to deal with the core issues of the person involved, to get a full rehabilitation in the right sense of the word.
It's interesting. I think when TJ started in the criminal courts, the shop theft was regarded as a very narrow issue as well. And it's about saying that, you know, that broader concept of rehabilitation is not just for this case, but for the future as well. But it's interesting.
Today in Israel, we have drug dealers and also a very different source of criminal activity who are dealt in a rehabilitative perspective. And the success is there is a very high rate of success, and it's a great thing. I wish they could adopt this concept into insolvency. Maybe maybe they will help the real solve the real issues of
yes, it's interesting.
I found this really fascinating. And like Michael and others, I've really never made this connection or thought about it at all. I just thought, well, bankruptcy, that's a whole different thing. It's not my bag. I don't know much about it, but I know people, you know, get into trouble and they petition for bankruptcy and they get it, or they don't get it. And really, I had never considered this. So I'm just fascinated by it and delighted that you're engaged in this.
Yeah, thank you.
Judge, I was struck. I'm sorry, Shelley.
No, that's okay, Kathy. Go ahead.
Okay. Thank you. Judge, first of all, thank you for your remarks. I was struck when Ite put the language up about the rehabilitation law, that it seemed to me, as compared to bankruptcy law here in the US, that there is language there that could be seized upon to expand the focus a bit. I understand the only actual remedy, the power that's given to the judge, is about discharging the debts, but there were references there to, you know, social values and to relationships or you know, others. And that seemed to me very unusual to see in a piece of financial legislation. And it struck me because here in the United States, we have a form of debt that probably many of you don't have because of our non-system. But you know, we have many medical bankruptcies. And you may have some parallel because people who, of course, get sick and can't work then cause insolvency. It's that affects those kinds of insolvencies affect so many other people and family. And I wondered if there is an opportunity, given the limited charge in terms of your responsibilities for debt discharge. Is there an opportunity at all to consider the impact on the family members, for example?
Yes, I think that the Israeli judicial system is based on giving, it's based on the English judicial systems historically, which gives the judge presiding a lot of discretion regarding his considerations of whether to give discharge or not to give discharge, to give a suspended discharge, and so forth. So basically, when you or me, when I think about giving a discharge, I can also take into considerations family considerations, the way that a certain person, like for example, if he was a drug addict or an addict to alcohol, he had an addiction to alcohol, I can see the way he did in life in order to assess whether he is like in comas, like is worthy of rehabilitation, in order to make it easier on him to receive the rehabilitation. So basically, the answer is yes. I think that unlike the United States, in which bankruptcy judges have a relatively narrow scope of considerations, in Israel and in England, they have a much wider discretion, and they can act if they think it's justified. They can act to help a person without a written order in law. For example, it's based on the general discretion of the judge, and lucky for us, the system is flexible enough, and the law and his interpretation is flexible enough to allow us to mold the situation as we see fit in order to help the debtor in order to achieve rehabilitation if we think he is deemed to receive it.
In this context, that seems like a wonderful ability to incorporate the principles of therapeutic jurisprudence. And I'm so glad to hear of your work.
Thank you.
I agree. This is so fascinating. And it seems like it's an area that just has so much work that can be done moving forward. I just wondered, Judge, whether in the research you've done, and I think you spoke to this a little bit, you said the Israeli system and the English system have a little more flexibility. Have you seen any other jurisdictions that are that move more explicitly to that broader sense of rehabilitation that you see as ideal?
Not that I saw. In fact, the only other law, as far as I can tell, that puts rehabilitation under his name is Japanic law in Japan, and there they copy paste the United States bankruptcy code with minor changes. But the overall the overall situation in the world, in the Western world, in the modern world, is that legislators tend to give people what they need, which is solve the economic problem. Mm-hmm. I don't know if the legislature think that it's the court's duty or the court's role to solve other core issues of the debtors. It's a political question. It's not a legal question. And we should be aware of this question because there's a question of judicial legitimacy. If I, for example, can tell a debtor, go and commit yourself to a rehabilitation center from drugs or from alcohol, I don't know. It's questionable whether I can do it or I can do it.
Mhm.
If in an expansive interpretation, maybe I can, but other people may not may disagree on that. So
Mhm.
basically, I think it's a political issue. It's not a judicial issue, and we have to wait and see if legislators around the world will prefer eventually to tackle the more complex issues of people rather than focus on the economic problem, which is much narrower and is much relatively simple to solve. You just delete the debt. You don't take care of the person. You don't do anything to the person. You don't commit him to any process. You just delete his debt and send him on his way. Maybe it's time to think about more addressing this complex issue in another way, another attitude.
Kelly, can I add one thing at this point? Is that okay? I mean, what the judge just said, and this was really something I had thought about asking before, and Carney probably knows what's coming. One of the things that I try to do is to encourage all my friends who are in TJ, whose substantive area is not, my substantive areas, Judge, are criminal law and procedure and mental disability law, and to some extent, international human rights law. That's what I write about. But people whose areas are on the other end of the sort of legal studies spectrum. I just looked up on Westlaw. There has never been an article that has the words therapeutic jurisprudence and either insolvency or financial rehabilitation in the same paragraph.
Michael, it will come soon, okay?
Okay,
we will
thank you.
write it together. I wrote it in Hebrew. We will introduce it in few minutes.
Right.
It's exactly what we did here.
And my Hebrew kind of extends to Baruch Atah Adonai. I mean, you know that. I don't have very much in the way of vocabulary. But okay, that was the other thing. People still think that TJ is only an offshoot of criminal procedure. And I saw that in an American Law Review within the last few months. And I know that people like Shelley have been writing about it in other areas, and Kathy, in health law, in family law, but there is still, because that's how it started. And those of us who have been at it for 30 years, you know, that those are our areas. But this would be so important to the whole TJ community in the world to write something that is available, that's accessible, that's downloadable, you know, in such a way that the rest of the community says, oh, gee, this really has far-ranging applications beyond what we're used to. That would really be a gift to the world.
Yeah.
Thank you.
I'd like to add something about that too, because if you look at the origin of TJ, really started in mental health law. And then what happened was people who were, very few people were teaching mental health law at that time. Those who were obviously had some other area that they had to teach in, family law, things like that. And they're the ones who said, well, this is interesting, and gee, this conceptual framework might apply to my area as well. But you know, there was no one, as far as I know, whose areas were, you know, mental health law and bankruptcy. You know, so it would be impossible. So this is just a wonderful way of thinking this through. And as I said, I never thought of any connection. I just knew bankruptcy law was something I didn't take a course in and wasn't interested in, and it dealt with people who got into problems. But I never thought of all the situations that you're raising here about, even the one about medical stuff that leads to bankruptcy, let alone, you know, mental health and drug addiction and idea and something that needs to be just. I'm just blown away by it all, really. Thank you.
Me too. Me too.
Great. Thank you very much. And I would like to thank Jatzadon for this spectacular things and very
welcome. Thank you for the invitation.
Thank you very much. And I think, Arnie, that we will move forward to the next part. I will reshare my screen.
So I will say again, first of all, hello to Pauline and to David and Makoto and everyone. I'm so happy that you came to listen, and also I'm so happy that you like the connection. And that's why I wanted to speak about it, because it's something that I always think about really spreading the TJ idea and how it can be implemented in more and more areas. And when I thought about the insolvency, I read what the judge wrote about the rehabilitation, but we could add this idea of rehabilitation by meaning of TJ, and that's what we did, and we wrote a short article, which is not yet academic, but there is like let's say an important and let's say I don't know exactly how to say, it's like a newspaper for a community of people that are involved in conflict resolution in Israel. And I wrote a small article about it, and then we thought of introducing this. And Michael, we can improve it and make it really an academic article, because I'm so happy that you all found it as worthy that to write about it in TJ. So maybe we'll introduce the 4 aspects of TJ that we thought about them, and how they can contribute to the implementation of the law in Israel, and all this idea of insolvency and therapeutic jurisprudence. So first of all, the perception of the conflict as complex, as not a simple one, and the need to integrate multidisciplinary professionals in assessing the conflict, and really understanding the rehabilitation process not as one meeting with a judge, but as an ongoing process. I think that we can learn from the implementation of TJ in the community courts in Israel, for example, or of course from other problem-solving courts around the world. And as I always like to investigate and write about, is the importance of the therapeutic judging. And we can, of course, think about other aspects. We just choose those 4 for people that have no knowledge about TJ. And it's really exactly the point that you already talked about with the judge, that a person may be in the state of insolvency due to various reasons. And it doesn't mean that he, has to suffer, let's say, from a business economic failure, but it can be a poor medical condition, things that are connected to a workplace. And if one can understand this point of view, so the rehabilitation plan should be tailored to the needs of the participant, his abilities. And we think that in this way, a good rehabilitation plan can improve the chances of success of the rehabilitation. And for that, we think that in the court, there should be not only, let's say, a perspective of the law, but rather integration of really multidisciplinary professionals. And we can think, I know already what the court will say. We don't have money for this and etc. But we can, you know, we can suggest, and let's say, and let's see what will happen. But really, I think any person that come from something that is more therapeutic background can help more assessing the conflict and plan a good rehabilitation plan, a better one, let's say, than that one that only takes in account financial aspects. And I think that what we learned from TJ, and the thing that the TJ calls for learning from behavioral science and to learn, you know, not from the law, only from the law books, but rather from psychology and other disciplinary. So we really can think about the rehabilitation process as a continuous one that requires time, information processing, receiving diverse tools. And if we think about this as a process, it can help the system to understand that the participant in this plan sometimes can, you know, succeed, sometimes not to follow exactly the plan, and maybe to do acts that the court couldn't understand or receive, and then change again. I mean, it's a process. It's a process. If you compare it to community courts, it's a process that should take at least 1.5 years. And what we have now in the law, that there is a financial training plan that is conclude only 4 meetings, 4 short meetings that teach, let's say, the participant only about financial aspects. So we suggested that it will be more meetings, and again, not only the financial aspects will be taught to the participant, but rather to see what are his or her needs, what are the circumstances, and then maybe to think about giving an answer or helping, and all those other motives. And the fourth aspect that we think is very important here is really a therapeutic judging. When we met Judge Sadon and talked with him, we were so happy, as you saw here, to see how he's open-minded, and he didn't know about TJ, and now I think he knows better, and he liked all those ideas. So we can help, let's say, by giving trying to give tools and a way to think about how the judging in the process should be done, and all those things that we think about the therapeutic judge, expressing empathy, respectful conduct, active listening to the participant. And I liked very much the question about if it is, as I understood it, is if the judge can speak or to a member of the family of the participant. And I think, I'm not sure that it is done today, let's say, but it's an idea, yeah, that can be adopted in reality. And I think in the community in Israel, it can be very helpful We see it also in the community court that a man or woman, they need support of the environment so it can be very helpful. Itai, I was anxious and talked a lot. Maybe
No,
you
no, no,
want to add
absolutely.
something or
I think that it was very interesting, Carney, and in the end of the day, it's a very practical and important when it comes to insolvency. I think that we are now in times that when you take the global economical situation, even let's think about a young woman or a couple taking a mortgage a few years ago, and with the raise of the interest, you can find yourself in a totally different situation. It's on the daily news in Israel. And the fact that you find yourself in a state of insolvency, that you cannot pay your debts, or from any other reason that can be also exposed due to the situation, lead us to a fact that if we will do much more when we will focus on rehabilitation, we can reach a long-term and quality rehabilitation. And again, if I compare it to the community courts in Israel, and I assume in other places, it's much better to give someone an education, to give him a tailored-made plan, rather just expose him to like a financial training of 4 meetings, which are not focusing on his own problem. And when it comes to rehabilitation, we do need to make sure that we are adjust and building a proper plan for a person who suffer from a specific. And again, the involvement of the family and his close circle much increase the chances of a successful rehabilitation, because the process in Israel do take time today when it comes to insolvency. But seems like, again, we are not experts in insolvency, but mainly due to the need to see the serious attitude of one to the process by paying the different amounts in accordance to what the court has defined until you reach this point of the discharge. But as Judge Sadon say, it's more from economical perspective, and it's not taking into account the very many other aspects that are important that can drill down to the core problems of such a person.